Your Lordships and your Ladyship will, of course, have well in mind the width of the trial judge's discretion. But it is the case that from time to time the final appellate court does have to intervene to restate the long-established rule, laconically put by Lord Fraser of Tully-Belton in G&G, that the question is, has it been shown that the judge to whom Parliament has confided the exercise of discretion has plainly got the wrong answer? Now, in the field of ancillary relief, the principal case, or locus classicus, is of course the speech of Lord Hoffman in Peglovska. And it's in volume 4 at page 68, and I know that 5 of your Lordships and your Ladyship would have looked at this recently in Agbarges, so it's only 2 short passages, 2.5 short passages I want to cite from this. The first is at page 1372. At letter G, when talking about the reasons given by the trial judge, Lord Hoffman says these reasons should be read on the assumption that unless he has demonstrated the contrary, the judge knew how he should perform his functions and which matters he should take into account. This is particularly true when the matters in question are so well known as those specified in section 25(2). An appellate court should resist the temptation to subvert the principle that they should not substitute their own discretion for that of the judge by a narrow textual analysis which enables them to claim that he misdirected himself. And then over the page, Lord Hoffman pointed out that the discretion was particularly unimpeachable on appellate review when the discretionary exercise was the provision of ancillary relief. And at page 1373, just above letter C, he says, there are many cases, ancillary relief cases, which involve value judgments on which there are no such generally held views. And he gives some examples particular to that case. And then at letter D, he says, these are value judgments on which reasonable people may differ. Since judges are also people, this means that some degree of diversity in their application of values is inevitable and within limits an acceptable price to pay for the flexibility of the discretion conferred by the Act of 1973. And those principles were reiterated by my lady in Re J, which is in volume 5 at tab 76, at paragraph 12. Where my lady said, if there is indeed a discretion in which various factors are relevant, the evaluation and balancing of these factors is also a matter for the trial judge. Only if his discretion is so plainly wrong that he must have given far too much weight to a particular factor is the appellate court entitled to interfere. See G&G. Too ready an interference by the appellate court, particularly if it always seems to be in the direction of one result rather than another, risks robbing the trial judge of the discretion entrusted to him by law. In short, if trial judges are led to believe that even if they direct themselves impeccably on the law, make findings of fact which are open to them on the evidence, and are careful, as this judge undoubtedly was in their evaluation and weighing of the relevant factors, their decisions are liable to be overturned unless they reach a particular conclusion. They will come to believe they do not in fact have any choice or discretion in the matter. And just recently in Agbargi, I don't turn it up.
What was the particular conclusion which judges were, or the Court of Appeal was tending to force on judges there.
In that case,
Yes.
that was in relation to an aspect of abduction under the Convention.
Not under the Convention.
Not a non-convention your ladyship, just making sure that everybody's awake there. Not under the Convention. Not under the Convention. But the precise... Mr. Nagpal will follow on that. I don't know the answer to the question. If there's only paragraph 12 I've ever read, it's the only one that's relevant, Francis. But I will rectify.
Well, I shouldn't, of course, explain what I was getting at, but the case was about returning of children in quasi-abductions from non-convention countries. And a view had grown up that you always sent them back.
You applied the convention to a non-convention case. This was the ideology of Lord Justice Thorpe in the Court of Appeal, with all due respect to him, that he did say in a number of cases, Saudi cases, the Sudanese case, I do know this, that you will effectively apply the convention de facto, and the judge in this case declined to do it. The ideology, it was overturned, and that was held to have been an interference that was impermissible.
How is this line of argument reconciled with your earlier submission that the Court of Appeal have introduced a completely new principle?
They have, indeed, they have interfered impermissibly with the exercise of the judge's discretion.
Well, that's a principle. You don't tinker with the exercise of discretion. But I thought your earlier submission was Court of Appeal have introduced a completely new principle into this area of the law. That's not tinkering. That's not tinkering with discretion.
Sorry, my lord, I've put this badly, sorry. I've put this badly. That they were not entitled to introduce a new principle in this discretionary field where Parliament has vested the discretion in the judge. And I'm going on to demonstrate that it simply cannot be said that what the judge did in this case was wrong. Indeed, what she did in this case was right. And the introduction of a new principle by the Court of Appeal was demonstrably wrong. Can I develop that in a minute? I'll just come to that in a minute. Your Lordship takes the words almost out of my mouth. But I just want to say this. I'm not going to take you to it, but just the other day in Agbarji, paragraphs 39, 75 and 76, the second message from Agbarji, first, as we've seen, that the lower courts must stop for ideological reasons writing words into the statute that aren't there. The second message was the Court of Appeal must demonstrate a real principled basis for interference with the judge's discretion. Now, to deal with my Lord Phillips's point, the Court of Appeal were demonstrably not entitled to enunciate their new principle and to perpetuate the judicial revolution in circumstances where it can be confidently said that over the course of a long trial, the judge found the facts in this case and applied the current law impeccably. And it was for her to weigh this agreement. She allowed some discount from the result that would have obtained had there not been a prenup, explicitly so in her judgment. So if you look in our written case at page 52, what were the discounting factors that she identified?
Your paragraph number?
My 114.
Okay. Yeah.
Now, in 114, we had already identified how the judge had said, in a number of respects, the agreement was defective, unfair, extremely unfair. But she went on to make findings, which we set out in paragraph 114. One, that the foreign elements to the case would be afforded some weight and would act as discounting factors. Secondly, she had received from me an implicit concession that the prenup should be a discounting factor, since we had accepted that the case should be primarily adjudged by reference to need, with no intrusion of sharing. Third, the husband understood the underlying premise of the agreement would also find reflection. We've already discussed that earlier. He understood the underlying premise. He accepted that he was expected to be self-sufficient. As a man of the world, that was abundantly clear. His decision to enter into the agreement must therefore affect the award. And her award was £4.7 million net of all debt, plus the usufruct in 630,000 euros worth of foreign property. Was that a result irrespective of the way that the Court of Appeal looked at this, and I've made my submissions on that, but was that a result that she was entitled to reach on the facts of this case? Plainly, yes. Was that result a discount from what would otherwise have been awarded? Obviously, yes. If there had been no agreement in this case, would this husband have received more than £4.7 million net of all debt? Obviously, a great deal more. One doesn't have to tarry long in reflecting on the facts of Miller, where after a 2 3/4-year childless marriage, Mrs. Miller was awarded £5 million. There was no agreement, of course, in that case. So the argument that there would not have been significantly more received by this husband absent this agreement simply is not tenable.
I think the argument against you is that this always was a needs case because there was no matrimonial acquis. Acquisition, whatever. Yes, sorry, I'm getting European.
You're going all Euro on me, my lord. Yes.
Request.
As my lady explained in Miller, we can have this debate. You don't have to have identifiable acquiesce for the sharing principle to be engaged. At all. We don't have a strict rule of delineation of matrimonial and non-matrimonial property as exists in Scotland, for example. At all. And Lord Nichols, I have my dog-eared copy here from the House of Lords. Lord Nichols was quite clear that it might be that the sharing principle applies with less force in a short marriage case, but this wasn't a short marriage case, 8 years and 2 children. So it doesn't follow at all. It may well be that any claim for sharing would have been less readily received by the court or more difficult for skilled advocates to argue, but it does not exclude it at all. And we had put in our skeleton argument that sharing should not be ignored in this case, but it was wrung out of us that this was basically a needs case. I basically had more or less the same conversation with Mrs. Justice Barron as I just had with your lordship, except that her reason for pinning us down on need, amongst others, was the existence of the prenup. And so what I wanted to say is she identified the judge 2 ways in which this agreement would be afforded weight. One, this takes on from what my lord has just said. The husband would be confined to strict need. There would be no sharing at all, and it would not even be needs generously interpreted, to use my lady's phrase from Miller. And Joanna Miles has opined that in this regard, the Court of Appeal may have overlooked that this particular approach represented quite a significant affording of weight to this agreement. That's our paragraph 120. I'll just say for the reference to your lordship's note. Secondly, that when it came to assessing strict need, the husband's multiplicand would be reduced further by £25,000 from 125, which is held to be reasonable, to £100,000 a year, and that capitalises up to £875,000. Now, Lords Justices Thorpe and Riggs did not consider this first reflection of need at all, and they considered that the second step or technique of the judge, namely the paring down of the husband's needs from £125,000 to £100,000, was not a true discount at all. They thought it was, or they said, it was just a conventional paring down done by judges all the time. So they were able to hold that this was a case where the judge said, I am going to afford this prenup some weight, but then didn't, or only afforded it negligible weight. So they, having said that, they then went on to say the judge's exercise of discretion miscarried, they can interfere and re-exercise the discretion. And we have said in our argument, and we reiterate, that is classically impermissible territory for those judges to venture into. By contrast, Lord Justice Wilson was of the view that the judge erred in principle and should not have been exercising a Section 25 discretion at all. Rather, according to him, but by virtue of the existence of this prenup, she should have been exercising only a Schedule 1 discretion, having answered Mr. Todd's exact question affirmatively. Now, Mr. Todd recognises, implicitly, if nothing else, that a defence of the logic of Lord Justices Rich and Thorpe is almost impossible. If you turn to page 42 of his skeleton, we looked at this before the adjournment. he tries to defend Lord Justice Thorpe and Lord Justice Riggs on grounds that were not in fact expressed by them.
Sorry, page what?
42 in the second edition, and it's paragraph 6.3d1. Mr. Todd writes, the appellant says that she did give some weight because Mrs. Justice Barron said that she did. In particular, she, I think that must be a he, says that she discounted down from the appellant's open offer by 15.6% or 875,000 worth of capitalisation. This is the appellant's calculation by how much the capitalisation figure was reduced, taking into account the reduction of the husband's needs from 125 to 100. But that is not what Baron J actually did. In paragraph 148, she expressly said, and I read this earlier, the husband would be able to equity release from 2.5 million property having traded down to the reasonable figure contended for by the wife. This would give him 1.5 million, thus he would have far more capital than Mrs. Justice Barron had found. And then he does the sums and says, thus there was no discount down at all. And so your lordships can see here that in order to try and support, validate the reasoning of Lord Justice Thorpe and Lord Justice Riggs, my learned friend has to resort to an implicit finding, a sub silentio, tacit finding of the judge that she never made, which was that this was one of those stepped Duxburys, stepped equity release Duxburys, that first saw the light of day in the case of F&F. If you take volume 3 to look at F&F at tab 46, which is the first tab in the volume, I would make the observation that this is where Step Duxbury's first emerged, blinking into the limelight. That
I suppose it's true that every member of the court knows what you mean by Duxbury, let alone Step Duxbury.
Duxbury is capitalisation and revenue requirements. Step Duxbury is if you have a revenue need at a certain level during years of caring for children, then they can fall in what Lord Justice Thorpe rather quaintly called the years of dower, and it is possible in the... Well, he did, it's in here, I'll show it to you, in the years of dower. this one gets on, one's facing the years of dower, it doesn't seem quite as...
Someone's reached them rather a long time ago.
Well, I didn't say that. Yes. And then also, in terms of Step Duxbury, there is the question that if in the years of dower you haven't got all this tribe of children with you, you'll need a smaller house, and so you can release some equity and put it into your Duxbury fund. And this was the first case. I would point out that Miss Barron was junior counsel for the husband, so if your lordships don't know what a Step Duxbury is, she certainly knows what a Step Duxbury is.
Very well. Can you just remind me which volume we've moved to?
Yes, in volume 3.
Volume 3.
And it's at page 67. What was argued by the husband was that the wife's budget would go down when the children were evacuated, as if they ever do, and you could then, into the computer, postulate an introduction of £1 million worth of capital, and at letter G he says, I think that Mr. Lawrence has right principle and good sense on his side when he distinguishes between the years of maternal responsibility and the potential years of dower beyond. He has, in his computations, drawn a distinction after 17 years to reflect the younger child attaining 21. At that stage, his models postulate the introduction of £1 million of capital. This was never argued at first instance or in the Court of Appeal. There were no Step Duxburys done in this case. It wasn't part of the wife's case. The judge didn't call for these calculations. It wasn't a part of the Court of Appeal's calculation. But my learned friend sees our case, and he sees the force of our argument that this discount was manifestly given by the judge, and so he tries, by a process of reasoning that was not expressed by the judge or even by the Court of Appeal, to reinvent this case as a Step Duxbury case. At the next page of my learned friend's skeleton printed case, he says at 6.3d Roman 3 that the discount is not just referable to the prenup. It took account of the following. 1, it provided for a clean break. 2, the prenup. 3, the wife's fortune. And 4, the husband's entitlement under English law. But we say that the prenup aside, 1, 3 and 4, those aren't discounting factors at all. Those are factors that are part of the overall Section 25 matrix or discretionary exercise. So we do say that these are weak attempts to try and explain how the judge did not do what she expressly says that she was doing, namely to give effect to some degree or another to this prenup in the exercise of her discretion. And we say there was no basis whatever for the Court of Appeal to have interfered with the judge's discretion. And in a way, having made those submissions, the case could almost stop now. But as you've seen from my little list, I do have some other points to make. If there is, we do say, any criticism to be made of the judge's discretion at all, then it should be that she was arguably generous to be in the land of discount at all, given that she had found that there was wholesale breach of the traditional safeguards which rendered this agreement defective and unfair. Now, Mr. Todd says on page 42, which we're on, at the top of the page, which is 6.3a, second paragraph, unnumbered, he says as to safeguards that they are not an end in themselves, they are simply a way of forensically examining whether a contracting party's free will was truly given. That can't be right. If that were true, then the normal contractual factors of duress and undue influence would suffice, we submit. The reason the safeguards exist, we come back to what was said before the adjournment, is to ensure that a fully informed choice is made, not whether free will has been overborne. So we ask this question rhetorically: why do these safeguards of advice and disclosure exist all over the common law world where there has been statutory reform? Why are they so prominent in the judge's paper of 1998? Why are they so prominent in the consultation paper supporting families? Why do they find explicit statutory expression in the employment and discrimination legislation? And the answer is this: without advice and disclosure, you cannot make a truly informed choice about what you're giving up. Secondly, the marriage relationship is one of the utmost good faith, where the parties repose complete trust in each other. And disclosure is therefore an essential component of that relationship. Third, as this case demonstrates, prenups, as opposed possibly to postnups that are made after many years of marriage, prenups are often made in circumstances of emotional vulnerability. And the parties were in love, as the judge found, besotted, as the wife described their relationship in her affidavit at that time. They having conducted almost a whirlwind romance. So in those circumstances, why are we focusing just on intelligence rather than on emotion when one comes to weigh whether the absence of the safeguards in this case matters? Now, in our printed case, we set all this out in paragraphs 138 to 148. Which I'm not going to read out. I learned my lesson in white when I started reading out the case, and I've never done it since. And but it's 138 to 148, starting at page 58. But I would ask your lordships to focus on 138 and 139, where we say the need for separate independent legal advice and full disclosure is not to ensure that the party enters into the agreement knowingly or freely. This is not what Mr. Justice Bastaracci, I hope he's a Mr. Justice, meant by an informed. I haven't checked.
He was.
He was. I beg his pardon. The late Mr. Justice Bastaracci.
No. He's still
Oh, right. He's still with us, but he's retired.
I believe. Yeah.
But he is a chap. I didn't check what his sex was. As I read that, I thought I should have done that. Meant by an informed decision. That was hartshorn. And then there's the point that I was debating with my Lord Mance. If an agreement contains zero provision, then you don't need legal advice to know what that means, however clever you are. It's self-evident. An informed decision is one where the party knows what potential claims are being relinquished. A party's knowledge of what the agreement says does not achieve the purpose of legal advice. The purpose is far broader than simple knowledge. A party needs to be given advice by an ancillary relief lawyer who can advise that party in what circumstances he or she can make a claim and what they might be likely to receive. In Hartshorn, they were both lawyers, but not matrimonial lawyers, clever lawyers.
But you just said you weren't going to read your case.
Okay, just this. I wasn't going to read all of my case.
But I'm a bit lost. We're still on whether the Court of Appeal was right to overrule the judge's discretion. Are we?
We are. Okay, I'm not going to read the rest of it. Your Lordships have read that, and then in paragraph 139, I had in fact apprehended my Lord Mance's point about clever people here, and I have dealt with that, but your Lordships will have read that. And in 140, we point out that in the field on the Employment Rights Act, the Race Relations Act, the Sex Discrimination Act, and TULRA, Parliament has specifically provided that all agreements are void unless those that compromise a particular claim, and then only where there has been legal advice from someone who is not employed by or acting in the matter for the other party, or a person who is connected with the other party, for a reason. And in this case, I would say this, that one thing must surely be certain is that the advice cannot be given by a notary in the pay of the other party who has worked for that other party's family. Now, Mr. Todd says at page 27...
Why are you certain of that? I mean, the function of a notary is independence.
That the judge has made a specific finding that the function may be independence, but in circumstances where this notary was behind the husband's back, instructed by the wife to deal with the terms of the agreement and paid for that by that party and had worked for that party's family, that did not supply the necessary independence. But it goes further than that. You need a lawyer there to bat for you. You need a lawyer in the negotiations like the Crosleys had to help you negotiate it and to advise you about what your rights are. But the notary doesn't do that at all. Now, what Mr. Todd says at page 27, dealing with my Lord's point, is that my learned friend does, in fact, try to describe that the judge has misunderstood the notary's position, as described by my Lord Mance a moment ago, paragraph 4.9. He says in the second sentence that some of the alleged defects are born of a misunderstanding. In notarizing legal regimes, the notary's position is a judicial one. And so it's being said here that the judge has made a misunderstanding. There was no misunderstanding here at all. The so-called independence of the notary was part of their case from the very start. I'll just give you the reference in their opening skeleton without showing it to you. It's volume Appendix 2, page 102, paragraph 79. But the judge made a clear finding about this, which is in the judgment at page 80, at paragraph 38b, where Mrs. Justice Barron said the husband had no realistic opportunity to take proper independent legal advice on the terms of the prenup. The German draft was, as I have found, only shown to him 7 days prior to final execution. While I accept that a notary has an independent role within the German legal system, I note that the doctor took instructions from the Radmacher family, prepared the draft, amended it upon Radmacher instructions, had no input from the husband at all, and was paid for by the Radmacher family. In that sense, he was not truly independent. And while I'm confident he explained the terms of the parties in accordance with his duty under the law, that does not mean the husband received independent legal advice.
The emphasis, that sentence should be on terms. I mean, you've just been telling us that it's not enough. It's not enough just to say what the agreement provides.
Yes.
It's what it could have provided for.
What it could have provided, and what are you giving up? In circumstances, this is, if you turn to the agreement at page 119, my lord.
119?
119 of
Yes.
the judge's judgment. It's the appendix. It's the agreement itself.
Yeah.
The agreement records that the engaged couple, Catherine Radmacher and Nicholas Granatino, born respectively in Germany and France, both residing in London Southwest 7. And then it says over the page, marriage contract, paragraph 1, preamble, we intend to get married on the 28th of November before the registrar of births, deaths and marriages in London, and to establish our first matrimonial residence there. So, circumstances where this marriage was going to be conducted in London His husband didn't have any independent legal advice about what he was giving up in terms of ancillary relief rights that he was going to acquire in relation to what was going to be an English marriage. Now, Lord Justice Wilson, at paragraph 138 of the Court of Appeal judgment, page 48 of...
Where does that take you? The husband might have thought that the prenup was going to be binding.
So where would the...
I mean, that doesn't seem to strike me as a disadvantage in this particular case.
If the husband had had independent legal... Your Lordship asked me the very question that Lord Justice Ricks asked me in the Court of Appeal.
Yes.
And said that if he had had an English lawyer there, would it have made any difference? Is that your Lordship's question?
Yes.
The answer is, there's a great irony here, and I was going to deal with this later, but I'll deal with it now. There is a great irony. This was signed, as we have seen, this prenup, on the 1st of August 1998, and if he'd had a sort of tame lawyer in the room with him, English ancillary relief lawyer, and had asked, is this agreement going to be, can I sign this agreement, or what am I giving up here? The lawyer would have said, well, I have here in my hand Lord Justice Thorpe's decision in F&F, which was published 3 years earlier, which is the latest word on prenups. And in that case, Lord Justice Thorpe says, in this jurisdiction, they must have very limited significance. And so the lawyer would have said, sign away, no court in England is going to uphold that, to which Mr. Granatino would have said, there's no chance of that, or Mr. Justice Thorpe changing his mind, is there? So no, of course, there's no chance at all of him changing his mind. Of course, that is what has happened. The law here, the goalposts have completely moved, and the law that was inapplicable there, which was they are of very limited significance, has now completely changed, so that this agreement has decisive weight against him. So the answer to your Lordship's question is that, in a perverse way, the provision of English legal advice at that time would be, yes, you are giving up your rights to ancillary relief, you're giving up rights to your claim to maintenance in any circumstance, you're giving your rights to any share of capital. But don't worry, no court is going to hold this against you on the laws that's existing at that time.
Well, that would have made him all the happier to sign it if he were looking at it from the point of view of that he was renouncing something. But as the point's been made, of course, he may have been very worried about the enormous amount he thought he was going to earn in the course of the marriage, and then it would be distressed if told that this prenuptial wasn't worth the paper it was written on. Well, I mean, that's still no reason why he shouldn't sign it nonetheless. It's not going to do any harm.
Well, I mean, that may be right, but this is the problem with every counterfactual exercise. You just don't know. That until somebody has told him, and it has to be advice given on proper disclosure, here's your wife, she's worth £100 million. Are you going to sign this? You might have a stroke. You might be rendered incapable of earning a living. So in circumstances, he doesn't give up his job because of the circumstances in which he did give up his job, which was by agreement in order to go into a doctorate at Oxford. You might have a stroke, you might be run over, right? And so you can't make a claim against her. You're going to sign? Because English law won't allow that. Are you going to sign?
That's still counter. But it runs counter to your argument. The minute he's given the reassurance, but of course, if something disastrous happens like a stroke, then it may very well be that the English court will temper the rigour of the agreement.
That's the point, though, temper the rigour of the agreement, rather than giving full relief. And so the scheme of the law has always been that people must know what they're giving up. This simply did not happen in this case, and the reason it didn't happen in this case is they were all absolutely in love with each other and besotted.
Presumably he thought, presumably he knew that he was giving up something. Equally, he thought that his wife was giving up something, as my lord's pointed out.
Yes.
It's not a case where, for example, they were aiming at some sort of consensual arrangement as to what a court would arrive at, in which case you might need legal advice. What they were aiming at was a perfectly clear, and one would have thought, adult and agreement between two professional people who wish to retain their autonomy and their independence financially, and that's presumably what happened subsequently, though you can tell me about that.
Yeah, I mean, your Lordship raised an interesting point because there's a great trio of Canadian cases about this, and Justice Lebel specifically said that if parties do try to predict the outcome of the discretionary exercise in their prenup, they do actually try to aim into the zone of fairness, then that is much more likely to be upheld than one that is aiming well outside the zone of fairness. But your Lordship has said that, ironically, that if you were trying to aim into the zone of fairness, you would be more needing legal advice, even though those are the sort of cases that are more likely to be upheld. So one ends in a sort of rather going round in circles, chasing your own tail, really.
I mean, I think on your argument, only if they're made following legal advice. But what I'm suggesting is that in this type of situation, you actually don't need legal advice. It's quite obvious what you're doing. You're preparing, you're agreeing to treat yourself as an autonomous being.
Well, this is where, I mean, I'm not going to repeat myself. I had this discussion with your Lordship earlier. The fact is, he did not know what he was giving up.
That's a different point.
Yes, I mean, sorry.
He didn't know what he was giving up because he hadn't got the facts.
No.
But he did know whatever was there, that's what he was giving up.
He didn't have the facts.
That.
He didn't have the facts because those had been kept secret, and that's
now,
the word that was used.
He was told by the notary that it wouldn't necessarily stand up.
He did, he was. You've seen that. There was a letter written afterwards.
But as I said, as a matter of logic, if you're thinking of entering into an agreement, to be told, well, it won't necessarily stand up is not really going to make you disinclined to enter into it at all.
You have to understand the circumstances as found by the judge in which they did enter into this, my lord. This wasn't a sort of cold arm's length negotiation. It's paragraphs 34 and 35 of the judge's judgment at page 79. This wasn't like sitting down in some office in the city, some arm's length commercial negotiation between two great corporate entities. What the judge said, given the time available, it's not surprising that he said, as I find that he didn't need a translation. I don't think he was made aware that the doctor wanted him to have a translation, to give him a proper opportunity to consider the precise terms and to see a lawyer. All this was, as I find, extremely unfair to the husband, because he had no realistic period for mature reflection or opportunity to take proper advice. Moreover, given the wife's attitude that this document was more for her father's than her own needs, I am satisfied that the husband took it far less seriously than he should have done. To this extent, he was lulled into a false sense of security. The young couple were deeply in love, and as they saw it, the piece of paper was much less important than pleasing the family and making preparations for their wedding. It is for this sort of reason, amongst others, that the English courts have been reluctant to enforce prenuptial agreements per se. So those were the circumstances as found by the judge into which this agreement was reached. And there's no disputing that Mr. Granatino is an intelligent person who can understand what words literally mean. I used the word correctly for once. Knew what he was signing in a literal sense, but he didn't know the full story at all.
You say they were madly in love, and she says, unless you sign this, my father's going to disinherit me. Is any man who's madly in love going to say, oh, well, never mind, perfectly happy to... with that, I'm not going to sign it. I mean, if you're madly in love with a woman, she says, unless you sign this, my father's going to disinherit me.
Yes, which he accepts was said to him. So those were the circumstances in which he signed.
That's a point in your favour.
It is in a different context.
I know, I've got that. I've got that. I understand that entirely. I'm not bridling it. Maybe I don't seem sufficiently grateful. I'm sorry for that.
There are different policy considerations. One is that you may emotionally be over a barrel when you agree to the prenup, in which case you shouldn't hold the person to it. It's quite a separate thing to say, oh, well, if only he'd known, then he might not have signed it. They're different points.
They are different points.
The first point, over the barrel, I can see that if your beloved fiancé says, unless you agree to this, which my father is being very difficult, he's simply going to disinherit me. Well, anyone in love would say, oh, well, in that case, fine.
Yes, that is...
but that's not lack of knowledge. That's simply whatever you knew as to the precise detail would be irrelevant in that circumstance.
I think what your Lordship is saying, that I'm sort of muddling up, with my love point, that I'm muddling up the fact that it in fact completely clouds your judgment And that doesn't impact, your lordship is saying, on the question of knowledge. But it doesn't dilute from the validity of the knowledge point anyway.
It introduces other factors than pure self-interest.
It does.
Is the point my lord is making.
It is, which I'm
When
being
you're
a
in
bit-
love with people, you take into account their interests as well as yours.
You do.
It's one of the things you do.
It's in all the poems.
Now, that may be quite logical, but it is an emotional factor.
It is.
It's one of the things that makes this situation different. Of course, there are other knowledge points that might, in theory, have been relevant in this situation, because we have whatever range of matrimonial property regimes are available in Germany, whatever range of matrimonial property regimes, and there are many, that are available in France, and we have the actual situation on the ground in England where they happen to be getting married, setting up their first matrimonial home, and having their children.
Yes.
That range of possible ways of sorting things out just doesn't come into the facts of this case, does it? But they were all there.
They were all there. I agree entirely. I do agree entirely. There is this one point, Lord Justice Wilson, paragraph 138. At page 48. In paragraph 138, Lord Justice Wilson accepts that the husband did not have independent legal advice, but he dismisses that defect. And he goes on to say that, in paragraph 140, he says that it may be that, even if only in the interest of simplicity, any legislative reform of the law's treatment of nuptial contracts will include, for example, as a condition of their presumptive dispositiveness, a requirement that independent legal advice should, in every case, irrespective of its surrounding circumstances, have been received in relation to them by both parties prior to execution. But the fluidity of the present law, perhaps at any rate, enables the court to apply common sense to a situation in which, as here, a husband well understands the effect of a contract, has ample opportunity to take legal advice, and decides not to, not much opportunity, and thus to reject his argument that in the absence of such advice enables him to escape its effect. So one has the extraordinary situation here that when this was signed, the law was that these agreements were of very limited significance. So the husband signs under that regime. When this case comes to be tried, or when this case of appeal comes to be heard, the absence of legal advice, in a common sense way, is dismissed because the husband is said to have known what was happening. But Lord Justice Wilson seems to acknowledge that just round the corner, Parliament is going to impose a system where, as a requirement, legal advice should be obtained. And so the husband finds himself in a worse position than he would have been under any reforming statute. So we do say in relation, just to conclude this section, that this prenup was plainly irredeemably flawed. We do say that the concealment by the wife of her wealth violated the utmost good faith on which their future relationship was supposed to be founded.
Where do you get that concept from?
Of good faith.
Yes, marriage being a relationship of utmost good faith.
I get that from Simeone in the Supreme Court of Pennsylvania.
Oh.
And I could say that, having once upon a time studied
Did I get
canon-
enough into that? Oh.
Yes. I could say that it's also a tenet of canon law, but we won't finish this week if we go anywhere
let's not do that.
But I'm not going to. If you look, I'm just going to give you the reference.
The reason that I'm asking you, Mr. Austin, is that the concept of a contract of utmost good faith involves voluntary disclosure of everything that you think should be material in the context of an insurance contract, for example. Now, as far as I'm aware, there is no duty of disclosure between a married couple while they are married of what their assets are and what they earn and so on. I have no right to know what my husband's income is any more than my husband has a right to know what my income is. So that was why I was worried by this notion that it's a relationship of utmost good faith in the usual sense of that term.
All of the judges, Simeone is one of the most, we'll come and look at it in a little more detail later on in a different context, but Simeone is one of the most famous prenup cases in the US. And it's a decision of the US Supreme Court. It's dealt with in my paragraph 30 through to 36 on pages 14 to 19. And the judges there, this was decided quite a long time ago in 1990, so it's 20 years ago. The judges there were all in agreement that the nature of marriage required there to be disclosure given, and the concept of marital relationship in one of the utmost good faith, as at the time of it being contracted, was famously advanced by Justice McDermott in his dissenting opinion on the result. He says, if you look at page 17 in the third paragraph, where he says, in my view, one seeking to avoid the operation of an executed prenuptial agreement must first establish by clear and convincing evidence that a full and fair disclosure of the worth of the intended spouse was not made. This court has recognised that full and fair disclosure is needed because, at the time of the execution of a prenuptial agreement, this is opposed to during marriage generally, the parties do not stand in the usual arm's length posture attendant to most other types of contractual undertakings, but stand in a relation of mutual confidence and trust that calls for the highest degree of good faith at the time that they're entering into their prenuptial agreement. In fact, but your ladyship will be aware that, of course, if one analyses, I don't want to spend too much time on this, analyses the norm of nullity, there are disclosure obligations imposed by statute in relation to disease and things like that before you contract a marriage, and we all know that if you misrepresent your position before marriage, then that will may invalidate the marital consent. And so the idea that you have no duty of disclosure at all when making a premarital contract or the marriage contract itself can't be quite right. But if your ladyship asks where I got it from, it's from there.
Where would you stand if someone said to their potential spouse, I want you to enter into this agreement and I won't marry you otherwise. Please go away and take as much legal advice as you like. But I'm not going to disclose my assets. I may or may not be rich, but I love you very much and I want you to marry me for myself. Would that be valid?
Doesn't sound very romantic.
Well, maybe the whole thing is.
I mean, so I'm coming on when my next theme, which I hope to finish today. I'm coming on for my next theme.
You could put it
my
more
principal submission is that, I mean, one has views about these things, but and I don't know what your lordships and ladyships' views are about the merit of prenups. You don't know what mine is, but there is a view that the formation of marriage should be attended by bridesmaids and not fashionable divorce solicitors. But the answer to your question is, if somebody says, take it or leave it, I'm not giving, you can take as much advice as you like, but I'm not telling you how much I'm worth, would a court, and somebody did marry in those circumstances, would a court uphold the agreement? Well, that's a moot question. It's not that far away, is it, from the not uncommon scenario, which was M&M, which was where the advice was, don't sign this agreement. Don't sign this agreement. And then there's a certificate attached to the agreement saying, I've given legal advice, which is don't sign it, but they sign it nonetheless. But in M&M, Mr. Justice Connell said that the wife felt under terrible pressure. She was pregnant. That may be part of the factual scenario the Lordship has in mind. She was pregnant. She felt under pressure. Her lawyer said, don't sign it, but she signed it anyway. That agreement confined her to 275. Mr. Justice Connell gave her 875. It would be a matter for the discretion of the judge on a very fact-specific basis, but I would suggest that if you deliberately withhold disclosure, and you say go get as much advice as you like, somebody signs it, that agreement's not going to be worth very much, because the person who's not giving the disclosure must know, surely, that in those circumstances no court is going to place much weight on that agreement.
I mean, 12 years ago, if this husband had asked, well, what am I giving up if I sign this, knowing that the wife is worth, let us take it, 100 million, what is he giving up?
12 years ago?
Yeah.
Yes, well, I mean, in F&F, you asked the question which was decided 15 years ago.
Well, I asked 12 years because that's when this particular agreement was signed.
Yes, the husband was worth 200 million and Mrs. F got 8.
But that assumes that the point will arise in an English proceeding.
Yes. But the notary did specifically advise them that this was likely to happen. He wrote the letter to them afterwards. And where is that letter here? I can't put my finger on the letter, but he wrote to them afterwards. It's in the papers. I'll find it. He wrote a letter saying, you must take advice in the country where you're going to live. And you must think about republishing this agreement in the country in which you live, because Anglo-Saxons don't do...
But it's not enough to say the country where you live. You've got to say in one of the many countries you may end up at the time of the divorce.
Yes.
It does actually say first matrimonial residence at page 120. I mean, there is a hint that they might move around a bit.
Yes.
Sorry, Mr. Mawson, the answer
JP
here...
Morgan Banker, I mean, I'd take that point.
Sorry, this 8 billion, I mean, was that acquired, any acquired assets here? We haven't got any acquired.
No.
There were none acquired.
No,
there.
Mr. Shackleton was
Okay.
his solicitor, so she can...
Right. I mean,
her solicitor, I beg your pardon. I didn't want to make that mistake too often. So that is all I wish to say about discretion. So I wanted to come now to, very briefly, the great debate. But I can be very brief, because the great debate, our fundamental submission, is that it is to be left for Parliament and the Law Commission, or rather the other way around. We've set it out in our section Roman 5, and there is no doubt that at every level, whether it's professional, academic, and indeed popular, prenups arouse great controversy. And you said that, by definition...
I thought the Court of Appeal agreed with this. They said the same thing.
They do.
I mean, they were allowed to express a view for the benefit, were they not, of those law reformers who will grapple with it in the future.
Yes.
But they didn't pretend that they were entitled to give effect to their view.
They did give effect to their view. They said they weren't, but in effect they did, for the reasons the submissions I've already made.
Well,
manifestly.
But I mean, why do you need to persuade us that I mean, they agreed they weren't law reformers.
No, I'm not going to spend any time on this at all. Just to say that I give you an idea. In our page 13 of our printed case, we have set out, we hope fairly, the arguments for and against. I say no more than that, apart from noting that, as you would expect, surely nothing less from me to draw your attention to the fact that mainstream feminist thinking roundly condemns these agreements as being oppressive and discriminatory, because the purpose and effect of most of them is to protect the wealth and earnings of an economically superior spouse, usually male, from being shared with an economically inferior spouse, usually female. There is this point to be made in relation to the great debate, my Lord, that in MacLeod, for the reasons given by my lady on behalf of the board, the prenup was sharply distinguished from the postnup, and in this case, the Court of Appeal dismissed that distinction, although one might have thought it was a statement of the obvious. It said that, by Mr. Todd in his printed case, there is no difference between the situation where a husband says, weeks before the marriage, sign this, or there's no marriage, and one when he says a few weeks after the marriage, sign this or I'm off, or you're off. There is a difference. We would suggest that the latter is firstly completely implausible. I haven't encountered that in 30 years. But secondly, the wife will have ancillary relief rights, and even short marriages attract ancillary relief rights, as Mrs. Miller proved. And thirdly, Parliament has drawn a clear distinction between the two scenarios. And the arguments for reform we've set out in our printed case, but I won't dilate on them at all. So I move now to my fourth theme, which is this: other countries, and the nature of legislation where adopted by common law countries. And again, I can deal with this briefly. We have set out in our case in some detail the position in those countries closest to us in terms of legal origin and tradition, namely those countries that had the old common law rule of nullity but have decided to go down the route of alteration of that prescription and a degree of recognition. And we've dwelt in our printed case on New Zealand, not only because it's a country culturally very similar to our own, but because their scheme has been in place for a long time, it's entirely a creation statute, and is highly prescriptive. Now, as you have seen from our printed case, my Lord, in their statute there is a requirement of writing, independent legal advice, and certification. If one or some of those criteria is not present, the court may uphold the agreement if there is no material prejudice to any party to the agreement. But the cases have clearly established in New Zealand that the burden to show this is squarely on the parties seeking to uphold the agreement. And as we have, we think, shown, Lord Justice Wilson would reverse that burden in this and presumably in all other cases where the safeguards have been breached.
Am I right that neither in Australia nor in New Zealand is there any statutory requirement of disclosure?
Of disclosure? The
You've got page
No,
33 is
that's
where,
right.
where New Zealand is set out.
I agree.
I can't
It's
see it there.
advice.
Pardon?
It's advice, writing and certification. I agree.
But, I wonder whether you're going too fast. I mean, I'm looking at 10C in paragraph 60, which is the agreement was unfair or unreasonable in the light of all the circumstances. Now, it doesn't actually say so in terms, but would one be able to build into that the idea if one party was concealing material from the other party, which the other party wanted to or needed to have to an informed case?
I agree with my lord explicitly so.
Yes.
But your lordship rightly points out that you could certainly, between the lines, divine a requirement of disclosure.
Well, I'm just looking at section 21.
As amended or as original?
Well, whatever we've got in the bundle.
It's it is in fact a quotation from section 21.
Yes.
21.
I'm just looking at what we've got
subsection
in the bundle, which is in tab 95. I don't know if that's the original or whether it's
In volume...
in volume 6.
6. Yes, that's the old one. That has changed in 2002
Yeah.
to the, the new one, which is in our paragraph 64. But it's the same provision, which is in, it's now section 21J 4C.
The only point I was trying to get at is that, and so please tell me if I'm to ignore this, it says that in every case the witness shall certify that before the party whose signature he has witnessed signed the agreement, he has explained to that party the effect and implications of the agreement. And given that the agreement is about defining property, dealing with property, defining the share of the property and so on, that
You have to know.
we're going to have.
You have to know.
Implicit in that, there has to be a level of knowledge to enable you to understand what the implications are.
My lady, can I, just for the purposes when you come to consider your decision, point out but tab 96 is the one that came into force in February 2002, when the Matrimonial Property Act was renamed and extended to all relationships, and the paragraph you're looking at is 21F, which is on page 69, subsection 5, and my Lord Hope's provision is still there.
I was looking at 10C. Is that,
Yes,
that is still there?
That is still there at...
21J4D.
Yes, thank you. J4C.
Yes, yes,
Yeah.
thank you.
Mr. Todd says that in relation to the USA, when we went only to Washington, that's Washington State, we've been too selective. And he points to the fact that the Uniform Premarital Agreements Act has been adopted in 27 states in the US. And he cites Rhode Island, but there has not been universal contentment with this statutory development at all. If you go to volume 10 and turn to page 158, just two short passages. This is the paper from Professor Ellman, well-known Professor Ellman in 2009. At page 14, the professor says, under the heading Special Rules Policing Premarital Agreements, he says in the second sentence, one traditional thread of American law represented by the public is constant thus both that enforces premarital agreements concerning the division of property only if, one, the parties had knowledge of each other's assets, either independently or through disclosure, and two, the agreement was voluntary, and three, its terms were fair, and 4, it's fair to apply at the time of divorce. The first is a procedural fairness requirement. It turns out an examination of the second is as well. The third and fourth are examples of requirements of substantive fairness. None are applied to ordinary commercial contracts. Button exemplifies the regulatory approach followed by some American states. At the other end of the spectrum is Simeone, which insists that premarital agreements should be treated like any other contract, with one exception, that it also requires disclosure. Simeone is a new development that few of other states have followed. Button is a traditional rule that many states have now abandoned. Most American states fall somewhere in between the two bookends. The UPAA, adopted in about half the states, is closer to Simeone than Button. And this orientation has motivated considerable criticism by many commentators, as well as the ALI. Many adopting states have modified the UPAA's recommended text to allow challenges that move back towards Button, as we will see below. Although one state, Rhode Island, that was the only one mentioned by Mr. Todd, changed the language to move in the opposite direction towards Simeone. So all is not happiness in the United States. If you turn to page 21 about the requirement of disclosure, the professor says, disclosure has probably been the most universal of the heightened procedural requirements applied to premarital agreements, required under both pre-UPAA law as well as the ALI principles. Even Simeone, the freedom of contract bookend, says that absent full and fair disclosure, material misrepresentation in the inducement may be asserted. Disclosure helps to show that consent to the agreement was knowledgeable, one important part of the voluntariness rubric, and concealment of one's assets in an effort to mislead the other spouse about them might be thought the kind of bargaining tactic that the rule was meant to bar. Section 7 of the ALI principles requires the person seeking to enforce an agreement limiting the other person's financial claims to divorce to prove that prior to the agreement's execution he had disclosed his assets and income to the other party, or that disclosure was not necessary because the other party already knew what they were, at least approximately. The UPAA's treatment of the disclosure requirement is therefore a puzzling shift in the law and one reason for criticism of the Act. So, as we say, it's not all happiness in the United States. There have been some countries where there has been judicial intervention. Mr. Todd points out that in Singapore and some US states, the development has been by judicial rather than legislative intervention. The case of Posner that was considered, the Florida case that was considered by the board, was one of them, although, as my lady pointed out, that was in the context of existing statutory provisions that allow variation of any agreement, whether pre or post. And then Mr. Todd takes us to Singapore. If you take volume 7, this is the decision of TQ and TR, which Mr. Todd says has striking parallels to this case. It's volume 7, tab 123. In this case, if you look at page 7, top right-hand corner, in paragraph 5 of the judgment, you can see that the husband was to pay a lump sum to the wife of $150,000 for her maintenance. The Court of Appeal upheld that in paragraph 7. But Mr. Todd, having said this, had striking similarities. If you look at paragraph 28 on page 11, about this case, which had a Dutch prenup.
A Dutch what?
Page 11, paragraph 28.
Yeah.
Said, in agreement with the judge, we made no orders for the division of matrimonial assets. For the reasons set out below, we decided that given the pivotal importance of the agreement, as a factor to be taken into account on the context of the division of the matrimonial assets, each party could keep whatever assets he or she might brought into the marriage. In any event, we noted that the issue might become academic for the parties concerned, simply because the husband asserted he had no assets, and the wife was unable to adduce any substantive proof to the contrary. However, given the public importance of the question, we will discuss the issue in some detail. So this was a sort of academic exercise. There was no money in the case at all. Wife got $150,000 from nothing by way of maintenance, but there was no other money. So everything they say, while interesting, is in the context of this finding that there was no money in the case. In the prenup, which follows at paragraph 29, it's a conventional separation of property, Dutch prenup, which says nothing about maintenance at all. And if you look at page 19, at paragraph 55, the Court of Appeal identify that prenups can be about A, maintenance, B, children, or C, division of matrimonial assets. And as to the first, at paragraph 67, they say, this is at page 22, which is a maintenance prenup. In the fifth line, they say, there is nothing preventing the court concerned from endorsing the substance of the prenup with regard to maintenance if it appears to the court that those terms embody what would be just and fair, which rather begs the question, really. And as to division of matrimonial property, they say at paragraph 71, well, first of all, they point to the statute, section 112 of the Women's Charter, and at subsection 2E on section 112, Parliament in Singapore has specifically required the court to take into account any agreement between the parties with respect to the ownership and division of matrimonial assets made in contemplation of the divorce. So the Singaporean Parliament has specifically put in its section 25 a reference to any agreement, and they held in paragraph 77 that E covers prenuptial agreements, and then they stated in their summary at paragraph 101 that, I beg your pardon, paragraph 104, the common tenet that runs through all the prenuptial agreements is they're ultimately subject to the scrutiny of the courts. And so we do say that in those circumstances where court scrutiny was emphasised, justice and fairness, but where the statute in question specifically required attention to be paid to any prenup, that this case does not really take matters very much further and certainly does not inform the decision that your lordships have to make. I now want to move to a more important point, which is Europe and the impact of community law. Can
I stop you there? Are you going to include Scotland at any point as part of either Europe or common law countries?
Yes, definitely part of Europe. Yes, I'm going to go to Scotland, and we've discovered in our council suite we're surrounded by Scots laws.
Yes, so, you should be fully informed.
Fully informed, exactly. But we are coming to Scotland. But we now, in Mr. Todd's printed case, he makes a big point that prenups are valid all over Europe, apart from the UK, Ireland and Malta. This is page 18 of his printed case, paragraph 3.1, he says, final sentence, in most civil law countries they are treated as binding, including the other states of the European Union, i.e. not Malta, England or Ireland. And if you turn to page 25, he says in paragraph 3.27 that parties in China, Japan, Brazil, Russia, South Africa, all the EU except Ireland and Malta, US, Canada, Singapore, Australia, New Zealand, Switzerland, Taiwan, Thailand and Turkey can choose whether or not they enter into prenuptial agreements. In such cases, they will be binding. Now, as to those assertions, we agree with this, but only, as it was once famously said, up to a point. My lords, before 1882, an English wife could not own property within marriage. On marriage, her property became owned by her husband, and she was under his couverture. In Europe, a wife certainly could own property, but marriage furnished specific rules as to how property should be held. The default position was usually that marriage would provide a community property, but parties could agree otherwise. And this facility stretches right back into history.
Your summary of English law is rather... it ignores the fact that any woman of wealth
marriage settlements
would have a marriage settlement, and contrary to what we've been talking about today, marriage settlements were the means of preserving the wife's fortune and not of doing away with it.
When your lordship says I've ignored it, what you meant is I haven't yet come to it.
Right. Yes. Well, you had moved on to other territories,
yes.
But no doubt you're
I am coming to that because it is important. And the question of whether you can have a proper foreign law in a marriage settlement is a very interesting one, which I will deal with, albeit briefly. But I'm definitely coming to that. there can be no doubt that an English wife could not directly own property within marriage before 1882. It was the effect of the 1882 Act that allowed a wife directly to own property within marriage. But for our purposes, the important point was that as a result of the Visigoths, we went into all this in Miller, and not getting into it again, is that the tradition on the continent was extremely different. So marriage contracts that provided for separation of property are very common and are used all over Europe. There's no question about that. But they are to be distinguished from prenups that seek to regulate maintenance, and particularly those contracts, as here, that contain a renunciation of maintenance. If you take the Authorities Volume Supplemental 3 and turn to tab 173, in the book European Family Law in Action, Volume 2, about maintenance, question on it's arranged like Dicey and Collins in that it's questions and answers. And question 102 is maintenance agreements. May the spouses enter binding agreements on maintenance in the case of a divorce? And if you turn the second question, which I meant to go to first, which is at page 475, question 103, may a spouse agree to renounce his or her future right to maintenance? If so, are there limits on that agreement? So this is the very question as in this case, where there was renunciation of maintenance. And the answer is that Europe is completely divided on this. About half of the countries you can make valid contracts to this effect. Austria, Finland, Germany, Greece, Hungary, Netherlands, Scotland, it says here, Spain, but only in Catalonia, and Sweden. By contrast, these agreements are completely void as against contrary to public policy in Belgium, Bulgaria, Czech Republic, Denmark, England and Wales, and the rural Hyman, France, the domestic contract, Republic of Ireland, Italy, Norway, Poland, Portugal, Spain apart from Catalonia, and Switzerland. So Europe is completely divided about whether spouses can agree to renounce his or her future right to maintenance. But it gets more complicated because in France, as the expert evidence showed in this case, and presumably in other cases, such agreements, although domestically invalid, may however be valid where they are made under an agreement where a foreign law is designated and that foreign law permits such a renunciation. And this is because of the 1973 Convention on the Applicable Law in Maintenance Cases, which is the law of France. So although this agreement, had it been signed in Paris and had designated France as its proper law, would have been void insofar as it provides for a renunciation of maintenance, because it was signed in Germany and had German proper law, which is applicable in France, it was valid. So, one cannot say with any certainty that there is a theme in Europe when it comes to a renunciation of maintenance. But more to the point, this is all going to change very dramatically on the 18th of June 2011 in every country in the EU except the United Kingdom. If you take volume 1 and turn please to tab 15, you will find there the maintenance regulation number 4 of 2009.
Sorry, which tab was it in?
It's tab 15. Now, this is the maintenance regulation number 4 2009, dated the 18th of December 2008. And if you turn to page 6, so L7/6, to recital 47, you can see that in accordance with Articles 1 and 2 of the Protocol, which establishes the annexed the Treaty of the European Union, the United Kingdom is not taking part in this regulation and is not bound by it or subject to its application. This is, however, without prejudice to the possibility of the UK of notifying its intention of accepting this regulation after its adoption later. So when this was signed on the 18th of December, we were not participating. But if you go to tab 10 now, you will see that...
Tab what? 10, sorry,
10.
I missed it.
You will see that a month after it was signed, we wrote to the Commission asking to come in. This is recital 3. And this is recorded in the Commission decision of the 8th of June 2009, which says that in accordance with Article 4, the UK notified the Council by its letter of the 15th of January 2009 of its intention to accept regulation number 4. Can I take you back to the regulation number 4, because I've been too hasty. In the actual regulation itself, on page 9, this is tab 15, there is a chapter devoted to applicable law, which says in, it's a very short chapter, Article 15, it says that the law applicable to maintenance obligations should be determined in accordance with the Hague Protocol of November 2007. So that's the rule about applicable law. It takes us off to the Hague Protocol of November 2007. Now, we were coming in, but then, if you turn now to tab 12, you will see that by November of last year, the Commission made this decision, which is, and this is recital 7, that the Protocol of 2007 shall apply between the Member States at the latest on the 18th of June 2011. So the new Hague Protocol on applicable law in maintenance cases comes in on the 18th of June 2011. But if you look at recital 11, it says that even though we've come in to the regulation, we're not doing this. It says the United Kingdom is not taking part in the adoption of this decision, is not bound by it or subject to its application. So we are not doing applicable law under the Hague Protocol of 2007. We're accepting those other parts of the regulation which deal with enforcement. And the protocol is appended to this decision. And if you look at the protocol on pages, the top right-hand corner of the page is 33119, you will see that it has some general rules of applicable law, but if you turn over the page and look at Article 8, there is some provisions about designation of the applicable law. And it says, notwithstanding Articles 3 to 6, the maintenance creditor and debtor may at any time designate one of the following laws as applicable to a maintenance obligation: nationality, habitual residence, property regime law, or the law applicable to their divorce. So in this case, you would have seen that the parties, in fact, designated German law as the law applicable to their property regime. So far, so good. But if you look at 4, sub 8.4, notwithstanding the law designated by the parties in accordance with paragraph 1, the question of whether the creditor can renounce his or her right to maintenance shall be determined by the law of the state of the habitual residence of the creditor at the time of the designation. And so you can see that the whole premise of the argument below, which was that this agreement is valid by the law of France and Germany, while it was true then that this formulation is in the departure clause, for if an agreement in identical terms to this were to be signed after June 2011, then the question of the validity of that agreement under both German law, French law, or the law of any other country of the EU would be determined by English law, because that is the question of the renunciation of maintenance, I hasten to add, because that is where the parties are habitually resident. And so that is going to be the provision for all of the EU states apart from the United Kingdom from June 2011. So this is one of those examples I would suggest of that famous billboard of 1911, fog in channel, consonant isolated. But we now know that in every country in the EU, for every country in the EU, the question of whether you can validly renounce your maintenance, it will be determined by the law of your habitual residence as at the date of designation. And so we do submit that the whole Euro comity argument of Lord Justice Thorpe is fatally undermined. How do I turn this back on? Apparently nobody can hear me, which is the first time anybody's ever said that to me. Sorry. I now come to the question of the impact of personal law in the ancillary relief exercise. In our part 10 of our printed case, which is on page 41, we show that the law in this area is in chaos, and we do submit to your lordships that this has to be resolved. In the case of Dart, Lord Justice Thorpe said that Thiessen was binding under the doctrine of stare decisis. In this very case, Lord Justice Wilson said that it is not. In Dart, Lord Justice Thorpe said there should be no looking at Michigan law from where the parties came. In Otobo, he said, let us look at Nigerian law from where the parties came. In Charalambos, he said, we must not look at Jersey law, which was the proper law of the postnuptial settlement in that case. In this case, he says, we must look at German and French law. In C&C, which is Charalambos at first instance, Lord Justice Wilson says we have a sideways look at Jersey law. In Bezardi, he says we shall not look at Iranian law. In this case, he says we must look at French and German law. It is, with respect, complete anarchy. And it is impossible to advise clients as to whether their personal law will or will not be taken into account by the court. And it surely cannot be a value judgment about the quality of the foreign law in question. And there are real problems. If you look at our paragraph 83, below we use the example of a Finn who'd married a Qatari who lived in London for the whole of their 15-year marriage. Paragraph 83, well, what are you supposed to do when you have a couple from very different backgrounds who happen to be and lived their marriage in London? How is the court supposed to reflect the competing cultural factors? And then there's the problems of the couples we describe as couple A and couple B, which we argued below. If you turn to Appendix 2, page 42, at paragraph 108. We asked the court to imagine two couples, couple A and couple B. Couple A both come from a country where the applicant would get nothing. If they were English, you'd get half. Couple B come from a country where the applicant would get less than half, but say still a significant percentage, say 35%. However, if they were English, you would get half. If Otobo and A&T were rigorously applied, the applicant in couple B would get 35% if they divorced in England, whereas the applicant in couple A would receive substantially more than zero if they divorced in England. Surely, we said, that respondent in couple A has a legitimate complaint. When it comes to couple B's nationality, the English court applies its law, but refuses to do so when it applies couple A's nationality. We've made the point in our printed case that in family law in general, we don't do personal law at all. You cannot come to this country bringing your personal law of marriage. We've advanced the proposition that somebody who comes to this country and wants to marry his deceased wife's mother, you wouldn't be allowed to do that, even if his personal law allowed to do it. Or his niece, even if his personal law allowed him to do it. And similarly in relation to divorce, are we going to have personal law? This is Rome 3 by the back door, which we have set our face against. In many countries, some countries, you can't get divorced at all. Malta. Are we supposed to reflect that? We say that the system is in complete chaos at the moment, and your lordships have to resolve the question of whether a party's personal law should have any impact in ancillary relief proceedings. And this takes us to a more significant point, as my Lord Walker has mentioned, the impact of a foreign proper law clause in a nuptial agreement. Now, there is a distinction to be drawn between an ante-nuptial settlement, which regulates provision to be made to parties to a marriage, and a prenup, which regulates provision to be made on divorce. And of course, the former is completely valid and are commonplace, and before 1882, they were the only way that a wife's money could be kept separate, as my Lord has pointed out. Those are specifically variable under section 24(1)(c), and it's almost the oldest surviving power, going right back to section 5 of the 1859 Act. Now, a nuptial settlement is only within the variation provisions if it makes provision for the spouses during marriage. If it's not, it is not within the section if it makes provision for the spouses for them after divorce, and that's Young and Young, which is in volume 3 at tab 171, decision of the Court of Appeal in 1962. Now, we accept that these nuptial settlements can have a valid foreign proper law clause. We accept that. But we go on to say that they are only relevant if someone dies or goes bankrupt, or otherwise in a situation out with ancillary relief. They are not relevant on a variation application under section 24. This is as clearly demonstrated by the decision of Charalambous, which is in volume 2, tab 33, at paragraph 31.
Sorry, volume
2,
33 is tab.
Tab 33.
volume 2, tab 33.
Paragraph 31.
Paragraph 31. In that case, the proper law of the nuptial settlement was Jersey. We see that from paragraph 16. It's the proper law of the contract. It's by clause 3.1. And Lord Justice Thorpe says, equally unavailing to the husband is clause 3.1 of the settlement. Once the wife has established the jurisdiction of the family division, the proposition that the husband has a right to the application of the law of Jersey and the determination of her variation, section 24 application, is completely misconceived. It is tried that a petition may only be defeated by a challenge to jurisdiction or stayed on a plea of foreign non-convenience. Once a decree has been pronounced on the petition, all ancillary issues must be determined in accordance with the relevant provisions of the Matrimonial Causes Act. Unlike many civil jurisdictions, which may inquire as to an applicable foreign law, this jurisdiction applies only the lex fori. In the specific instance of the variation of a post-nuptial settlement, the cases of Nunnally and Forsyth are conclusive. They have stood unquestioned for a century, and Mr. Francis' suggestion they are unreasoned, and therefore unpersuasive, mistakes their power. The proposition that they proclaimed required no more elaboration. And so there is no proper law on a variation of a nuptial settlement, even if that nuptial settlement has a foreign proper law. And this is confirmed in Dicey, Morris and Collins in Rule 91.7, which is volume 9, tab 148.
So you can have regard to the terms that the parties have agreed other than a choice of law term. Isn't that illogical? I mean, agreeing a particular law is another way of agreeing how the
Well, it's not.
contract
I was going to
work.
had actually anticipated your lordship's very question. The problem about a choice of law in a clause in a marriage contract, it's not illogical to give it recognition because it enables the parties to oust the jurisdiction of the court. It enables the parties to agree that section 25 will not apply to their case, but some other law will apply to their case. You can't do that under Hyman, section 34. You can't do that.
Isn't variation dependent on the meaning of the contract under the law of Jersey? So you must look at the law of Jersey to decide what it means in order to know whether it needs varying and how far.
Well, this was the debate in Charalambous, because it was being said that the law of Jersey prevented a variation.
Well, it wouldn't prevent a variation, because as I understand it, a variation is a domestic remedy which you can't oust. That's what Lord Justice Thorpe says here. But you're still varying something which is a foreign contract, and you must look at it as such.
Why can't you be varying the effect of the foreign law? A starting point is, what did the parties agree? Part of what they agreed is the foreign law clause and the way that works in the contract. There's jurisdiction to vary all of that.
There is.
But the starting point is, what are we varying, surely?
The starting point is, what are we varying? Are we going to
Yes.
vary this to give the wife such and such a provision, irrespective of whether the foreign law does or does not permit such a variation?
Yes, well, I can't. It's one thing to disregard ab initio the effect of the foreign law clause. Quite another thing to say, well, what did the parties agree, including the foreign law clause, and should we vary that?
Yes, yes. In that case, I don't think there's any difference between me and you, my lord, on this at all. In that case, it was being regarded that the court was hamstrung because of the terms of the foreign law, which was obviously not right. But whether how much attention is paid to the effect of the foreign law on what the settlement means, I haven't really thought about.
I think it's probably an absurd example. If the foreign law said there's a maximum of £2,000 per month that can be agreed. That was the effect of the foreign law. That's what the parties have agreed. You come along, and that can be varied.
That can be varied.
Yes.
But what can't happen is you can't say that because of the foreign law, you can't vary it.
If the foreign law says no other law is to be applied,
Yes.
then I can quite see that can't be conclusive.
Well, that's what was being argued, is that the court in England should apply the foreign law of the law of Jersey in the variation, but that can't happen. I'm not being so bold as to say that the court should completely shut its eyes as to what the common law said in exercising its discretion as to how to vary. So I don't think there's any dispute between us in relation to that.
But would you agree with me that although, as you say, there's Young and Young says that there are limits to what counts as an antenuptial settlement, which is, I think, the phrase that's traditionally been used, that it has, in fact, been very widely construed and may not in any way represent a contract or agreement made on the occasion of a marriage.
Oh, quite.
It's much wider than that.
Joint purchase of a house.
And the other thing is that whatever order the family division makes, there is yet a further dimension to it, whether the Court of Jersey is going to direct the trustees to give effect to it. But that's getting into questions of long-arm jurisdiction, which I think really aren't going to help us today.
No, not going to help. Yes. You're, of course, in a much better position if your Jersey Trust owns your property in England. The property's in England, and then the long-arm jurisdiction doesn't matter so much as the Jersey the court.
Well, if it's in England, 99 times out of 100, it'll be held through a British Virgin Island company or something. So anyway, I think we're getting rather far
I don't need
off.
to go there, but what I wanted to demonstrate was that the rule in Charalandis was reflected in Dicey, Morris and Collins in tab 148, on the second page of Rule 917.
I couldn't find this, I'm sorry.
148.
Yes, I've got
volume
148.
9,
And I've got Rule 91,
page 2,
page 2.
91, sub-rule 7.
Oh, right.
If a court has jurisdiction,
Yes, thank you.
Run this rule, it would normally apply against domestic law, and then this is being explained in the notes on page 13, which says in 18207, it's never been doubted that the court, when making an order of financial provision under the Matrimonial Causes Act, always applies its own law, irrespective of the domicile of the parties. And the only exception is to enforcement of foreign maintenance orders, where we may have to look at the foreign law to see if they're okay. Now, Mr. Todd says that this is in conflict with Rule 157, which is at the next tab, at page 7, which is the effect that the validity, interpretation and effect of a marriage contract or settlement are governed in general by the proper law of the contract. But we say that there is no conflict. Rule 91 is about ancillary relief. Rule 157 is about the governing law of the marriage contract or settlement. But the power to grant ancillary relief is statutory. It derives from the Matrimonial Causes Act. Once the Matrimonial Causes Act power is invoked, you are in the Matrimonial Causes Act territory, and it's English law that applies. You can't oust Section 25, either explicitly or indirectly by applying foreign law. And once you've pressed the Matrimonial Causes Act button, so to speak, a marriage contract is not enforceable under the law of contract. And so we do say that Rule 157 and Rule 91 sit comfortably. Rule 157 is relevant outside ancillary relief. If you wish to sue on the contract, or it becomes relevant in probate proceedings or in bankruptcy, then the government law applies and is relevant. However, if you are exercising the ancillary relief jurisdiction, was going to say it's irrelevant. I wouldn't say it's irrelevant, but the powers to vary are not fettered by the foreign law, the way I've described. So that's all I wish to say about antenuptial settlements, but I would go on to submit that a foreign choice of law clause in approval, should we submit, play no part in the discretionary exercise. If it plays a very limited part in the way that we described in a variation of nuptial settlement case, then a fortiori it should play only the most marginal contribution in the weighing of the void contract that is a prenuptial. And then there is this point, which is that the government has refused to opt in to the applicable law provisions of the Hague Protocol as applied by the maintenance regulation. And the reasons were given by the government. It's our paragraph 89 at page 43.
But I'm getting a little confused as to how far this matters. The only relevance of the proper law clause is that German law would regard the agreement as binding.
And French law by virtue of the
Yes.
73 Hague Convention.
So really, as far as this case is concerned, saying this contract should be governed by German law should carry no more weight than something that said this contract shall be binding in law, which is nothing. Yeah.
Well, I would agree with that, except that I have to come here prepared to argue very respectfully against Lord Justice Thorpe and Lord Justice Wilson, who said that the judge did not give sufficient weight to the foreign dimension in this case.
There's another part of the foreign dimension. If the parties are German and they conclude a contract governed by German law, when you take the whole package together, there may be some significance in the German element. But if they had said the contract should be governed by Chinese law, simply because that was going to give them an interpretation of the contract that they wanted to agree, that's no more significant than any other clause that they agree.
I agree.
And ergo, not binding.
I agree with that. However, I thought I have, from tedious length, tried to explain why, as a question of principle, questions of foreign law should play a limited role in ancillary relief proceedings, and why this whole premise that the foreign law is going to be relevant is all going to become history after 2011 anyway, so especially as regards maintenance obligations. My final point under this theme is that Agbaji has close parallels to this case. In Agbaji, the parties were ethnically Nigerian, who had a Nigerian divorce and a Nigerian order, and the question was what financial provision after that Nigerian divorce should be granted. And they'd been married for 32 years prior to separation, and of those 32 years, 25 were lived in Nigeria and 7 were lived in London. And in this case, the parties are ethnically German and French, respectively. They lived all of their marriage in London, apart from a brief sojourn in New York, and they had a foreign agreement before marriage, but they had an English divorce and an English ancillary relief. The total assets in Agbaji were 700,000. The Nigerian order gave the wife a life interest in 86,000, a lump sum of 21,000. Mr. Justice Coleridge gave the wife a needs-based award of 275,000, or 39%, and he paid little regard to the foreign dimension. In this case, the assets were 100 million. Mrs. Justice Barron gave the husband a needs-based award of just under 5 million, or 5%, and she gave the foreign dimension a modest reflection. In Agbaji, the Court of Appeal said the foreign dimension was of critical importance. Comity demanded proper respect being given to the Nigerian order. The order by the Court of Appeal set aside Mr. Justice Coleridge's order, and the wife was confined to her rights under the foreign order. In this case, the Court of Appeal said the foreign dimension was of critical importance. Comity demanded proper respect being given to the German agreement. The order of Mrs. Justice Barron was set aside, and the husband was confined to his rights under the foreign agreement, subject to a supplement qua father under the Children Act. Now, your lordships and your ladyship allowed the appeal in Agbaji, and you put forward 3 clear messages. 1, the Court of Appeal must stop meddling for ideological reasons with a proper exercise of discretion by a trial judge. 2, the lower courts must stop writing words into the statute that simply are not there. In that case, concepts of hardship, exceptionality, minimum remedy, were all glosses on the statute, and it was completely unprincipled, said your lordships and your ladyship, to read them into the statutory provisions. And thirdly, you said that the comity arguments had little relevance to the exercise. In paragraph 73, you said, where the connections with England are very strong, there may be no reason why the application should not be treated as if it were made in purely English proceedings. And in paragraph 76, you said the English connections are substantial, if not overwhelming. And you also went on to say that in part 3, there's a fourth principle, which is abasement of need. Now, we say, in this case, that the Supreme Court should allow this appeal for almost identical reasons. If the connections with England in Agbargi were overwhelming, then they are even more so in this case. If you look at our paragraph 157 on page 65 of our printed case, we refer to the judge's finding about the foreign dimension, where she said that they are definitely relevant foreign elements. We point out that the dimension was reflected in her disposal and in her discount. The weight to be attributed was a matter for her discretion. The discretion was unassailable, where it was undisputed the parties met in London, and then the whole relationship budded, blossomed, and withered here. Their intention to live in London was specifically recorded in the agreement, and the notary put the couple on notice that not every jurisdiction would implement the choice of law clause, and advised them to seek English advice as to the matters touched on in your prenuptial agreement. This is referred to in the judgment. If you look at part 3 of the appendix, look at part 3 of the appendix at page 142, you will find there the letter that was written just after the agreement had been signed by the notary to them both. And in the final paragraph, the notary says, finally, I must again inform you that before purchasing property abroad and taking up permanent residence there, the advice of a local notary or a solicitor on matters touched on in your prenuptial agreement, taking note of the existing agreement. If necessary, according to the present local form, please also note enforcement of the publication that may be required to be able to invoke the agreement against a third party. Something may have been slightly lost in translation, but I think that the sense of what he is saying there could not be more clear. And so we do say that there is a strong analogy with Agbargi. In this case, you could almost reissue that decision. In this